I received a phone call from a young man who was very, very upset. He said to me, "Tell me, can my stepmother take my daddy's property from me?" Well, I knew from that question what had happened. And I'm going to tell you. I'm attorney Vernita Williams. I practice law here in South Florida, and I often handle cases that involve last wills and testament, trust, estates, and probate cases in general. This young man came and he described a fact pattern that is very, very common. Father purchased a home from with his wife in the first marriage. Wife passed away, and in later years, he remarried. And of course, his children from the first wife ended up with a stepmother. Eventually, the father passes away, and the stepmother finds herself in one of four scenarios. And usually, this doesn't play out very well for the stepchildren. The first scenario is the father placed the new wife on the deed as his wife. And in this first scenario, if the father placed the new wife on the deed, then upon the passing of the father, this woman owns the property 100% free and clear. And guess what? She can even deed it or will it to her children that were not born to this man that passed away owning the property. So that's a very bad scenario a lot of times for the stepchildren. They're thinking, this man said this woman didn't have two nickels to rub together before she married my dad. And now you're telling me she can just take my dad's property and she can even deed it to her children that don't belong to my dad? Yes. Scenario number two. Well, maybe his dad did not put the new wife on the deed, but when the dad passed away, his stepmom said, "I want to live here. I don't want to sell it, but I want to live here." Can she do that? The answer is yes. She can, in the state of Florida, get a life estate to the property, and she can live there. Well, scenario number three is not any better. Scenario number three, the dad did not put his new wife on the deed to the property, and she says, "Well, he's gone. I no longer want to live here. I want to sell it." Can she do that? Well, in the state of Florida, for a homestead property, yeah, she can sell it. She can sell it. She can get her 50%. She can make that election. She has to make that choice within a certain amount of time after her husband passes away. But yes, she can sell it. And the fourth scenario is maybe your dad thought about the situation and said, "Well, if I pass away, I want my children to have this property." So maybe he did a last will and testament and he left the property for his children. Is this going to help you? Well, it's probably not going to help you in the manner that you would like, because in the state of Florida, if there's a homestead property involved, your dad just can't do a will and will it away from his wife. She still has rights, and she's entitled to either a life estate or to sell the property and get 50% of the proceeds. So this is probably not what you want to hear. So I'm doing this video so that those of you who might be in a situation, you have a step parent, and you're wondering whether they can take your parent's property away from you if your parent passes away, and it's the homestead property, the answer is probably yes. So situations differ. If this is a situation where perhaps there is a prenuptial or postnuptial agreement, the outcome might be a little bit different. It might be a lot different. So don't judge your situation by what I'm saying in this video. You need to hire an attorney, explain fully what has happened, and let that attorney make an assessment based on all of the relevant facts. So if you have a stepmother and your father has passed away, and your question is, can my stepmother take my daddy's property from me? Well, unfortunately, the answer is probably yes. If you would like more information, please call us. The telephone number is 786-831-9483. That's 786-831-9483. If you need additional information, you can also visit us on our website. That is vcwlaw.com, vcwlaw.com.